The night they gave me a standing ovation, my brother was already stealing everything I had built. 200 surgeons, department heads, hospital administrators, people who had watched me open skulls and save lives for 4 decades rose to their feet in that ballroom in Boston. They clapped for me. They raised their glasses. And Conrad stood at the podium with his hand on my shoulder, smiling the way only someone who has already won can smile. He said the words I will never forget for the rest of my life. He said, "The breakthrough that changed spinal surgery forever. The device that has now been licensed in 31 countries and has restored movement to over 400,000 patients. That research began with me." The room went quiet for exactly 1 second. Then they applauded him too. I stood there in a navy dress I had bought specifically for that evening, holding a glass of champagne I never drank, and I did not say a word. Not because I was afraid. Not because I was shocked. I stayed quiet because 3 weeks earlier, I had already found the document he used to take it from me. And I had already started building the case that would end his career in front of the same people who were clapping for him right now. If you are watching this and you have ever had someone take credit for something you bled to create, drop where you are in the comments. I want to know how far into this story you make it before you feel it in your chest. My name is Sylvia Hawn. I am 61 years old. And for 40 years, I was a neurosurgeon. Not the kind who shows up at galas and gets photographed for hospital newsletters. The kind who is in the operating room at 5:30 in the morning. The kind whose hands other surgeons watch when they are not sure what to do next. The kind who publishes research that nobody reads until suddenly everyone is using it. I grew up in Worcester, Massachusetts, the oldest of 2 children. My father was a general practitioner. My mother taught biology at a community college. We were not wealthy, but we were precise. That was the word my mother used. She did not say we were smart or disciplined. She said we were precise. That we noticed things other people let slide past them. That we checked our work. I carried that word with me through medical school at Johns Hopkins, through my residency, through 12 years at Massachusetts General before I was recruited to lead the neurosurgery department at Caldwell University Medical Center, which is where I would spend the next 22 years of my career. Conrad is 12 years younger than me. He followed me into medicine, which our father considered the highest form of flattery. He was charming in a way I never was. People liked Conrad immediately, the way they like someone who remembers your name and laughs at the right moments. He completed his residency in neurosurgery as well, though at a smaller program, and eventually joined the staff at a hospital in Philadelphia before transferring to Boston 7 years ago. We were never close in the way some siblings are. We were cordial. We had Christmas dinners and birthday calls and the occasional conference where we would find each other across a room and nod. That was enough. I thought it was enough. The research that would become the center of everything began in 2003. I had been watching a pattern in post-operative outcomes for patients who underwent spinal cord decompression surgery. The existing instrumentation was blunt in ways that troubled me. The margin of error during placement was too wide. I started keeping a separate notebook, not a hospital file, a physical notebook, the kind with the black covers you buy at a drugstore, where I recorded observations after each procedure. What I noticed, what I would change, what I believed was possible. By 2006, I had a concept. By 2009, I had a working prototype built in collaboration with a biomedical engineer named Dr. Felix Okafor, whom I had met at a conference in Chicago and immediately recognized as someone who thought the way I did, carefully, without shortcuts. Felix and I worked on the device for 6 years. We self-funded the initial development. I used savings. Felix used a small inheritance from his grandmother. We filed for the provisional patent in 2011 under both our names, and the full utility patent was granted in 2013. The device was a guided microtension instrument for spinal cord surgery. It reduced placement error by 63% in clinical trials. By 2016, it had been licensed to a medical device manufacturer and was being used in operating rooms in 14 countries. By the time I stepped back from active surgery in 2022, it was in 31. The licensing revenue over that period totaled approximately $47 million, split between Felix and me according to our original agreement. Conrad knew the device existed. He knew I had worked on it for years. What Conrad did not know, what I had never told anyone in my family, was the precise financial structure of the patent. He knew it was successful. He did not know the numbers, or so I believed. In 2021, I began to notice something. Small things at first. Conrad started asking questions at family dinners that were slightly too specific. He asked about renewal cycles for medical device patents. He asked, once, how licensing agreements were typically structured when one inventor was more clinically active than the other. I answered him generally. I thought he was curious. I thought he was making conversation. I was being precise about the wrong things. In January of 2022, I made a decision I would later understand was the moment Conrad had been waiting for. I sold my private practice and formally transitioned to a part-time advisory role. To the outside world, to my colleagues, to the hospital board, to my family, it looked like a graceful wind down. A woman of 60 who had done enough, choosing to rest. What it actually was a shift. I was not tired. I was redirecting. I had started consulting for a global medical nonprofit on surgical access in low-resource settings, which required travel and focus I could not give while still operating 3 days a week. But to Conrad, my stepping back looked like vulnerability. He had been married for 9 years to Lorraine, who specialized in intellectual property law, and had built a reputation in Boston's legal community for being extremely good at finding structural weaknesses in patent agreements. I had met Lorraine at various family events. She was precise in her own way. She asked questions with a lightness that made you answer before you realized you had said more than you intended. I liked her, which I mentioned only because it made what came later feel like a particular kind of cold. Dr. Felix Okafor remained my closest professional confidant through all of this. He had moved his research practice to a university in Atlanta, but we spoke every few weeks, the way people do when they have built something together, and the building of it never quite leaves you. Felix was the only person outside of legal and financial channels who knew every detail of the patent structure, the licensing terms, and the amendment we had filed in 2019 updating the revenue distribution model. He was also the only person I called the night I found the document. But that comes later. What you need to understand first is what Conrad did at my party. Not just the words he said, the architecture of it. Because it was not a spontaneous moment of arrogance. It was a performance that had been rehearsed, that had been built on paperwork filed months before I walked into that ballroom. That was designed to make 200 witnesses believe a version of history that had been constructed specifically to replace the real one. The celebration was organized by the Hospital Foundation. 50 years of practice, they called it, though I had been in medicine 40 years by that point. Someone miscounted, and I did not correct them because I was focused on other things, and also because 40 or 50, the number was not the point. Conrad had volunteered to give the keynote remarks. He told me he wanted to honor me properly. He said it with such sincerity that I remember thinking, briefly, that perhaps I had misjudged the distance between us. I had not misjudged it. I had simply not yet seen how far he had already traveled in the other direction. His speech lasted 11 minutes. For the first 8, he talked about our childhood, our father's practice, the way medicine had shaped our family. He was warm and specific, and people laughed in the right places. I stood beside him, and I listened, and I felt, for those 8 minutes, something close to genuine. Then he turned to the device. He called it a revolution in spinal surgery. He described the years of development, the clinical trials, the licensing success. And then, without pausing, without any change in his voice, he said that the foundational research had originated in a series of observations he had made during his own residency, which he had shared with me in the early 2000s, and which I had developed further with his ongoing guidance and collaboration. He did not say he invented it alone. He was too careful for that. He said he was the origin. That was the word he used. Origin. As in, I was the execution and he was the idea. As in, without Conrad Hawn, the device would not exist. I looked at him while he said it. He did not look at me. He looked at the room. And the room, because the room did not know better, believed him. I did not confront Conrad that night. People came to me afterward with their congratulations and their champagne and their carefully worded comments about what a lovely tribute Conrad had given. A few of them looked at me with something slightly different in their eyes, a question they were too polite to ask directly. I answered all of it with the same composure I had used in operating rooms for 40 years. Steady hands, steady voice, nothing on the surface that did not belong there. Conrad found me near the end of the evening by the window overlooking the harbor. He put his arm around my shoulder the way he had at the podium and said it had been a wonderful night. I said it had. He said he hoped his remarks had done justice to everything I had accomplished. I said they were memorable. He squeezed my shoulder once and went to find Lorraine. I stood at that window for another 4 minutes. I watched the lights on the water, and I made a decision that I want to be precise about because it mattered. I decided that I would not react until I understood the full shape of what he had done. Reaction without information is just noise. I had not spent 40 years in a field that punishes imprecision in order to make noise. I drove home. I poured 1 glass of wine. I sat at my kitchen table and I opened my laptop. The first thing I did was search Conrad's name alongside the patent number. What I found took me approximately 40 seconds to locate and approximately 3 hours to fully understand. There was a document filed with the United States Patent and Trademark Office in March of 2022, 9 months before the gala, under a section designated for inventorship correction requests. It was a formal petition asserting that the original patent filing had omitted a co-inventor. The omitted inventor named in the petition was Conrad Hawn. The petition included a signed declaration. The signature on that declaration was mine. I want you to sit with that for a moment, because I want you to understand what it means when someone uses your name, your credentials, and your signature to rewrite a legal document that determines who owns something worth $47 million. It is not an argument. It is not a dispute. It is an erasure. It is someone deciding that your version of history is inconvenient and constructing a replacement that they then attach your name to, so that when the replacement is discovered, it appears that you agreed to it. I had not signed that document. I had never seen that document before the night I found it on my laptop screen. I closed the laptop. I finished my wine. I went to bed. And I want to be honest with you about this. I slept. Not well, but I slept. Because I had already learned a long time ago that the body needs to function in order for the mind to do what comes next. Panic is a luxury I have never been able to afford. In the morning, I called Felix. It was 6:45. Felix answered on the second ring because Felix has always answered on the second ring. And for a moment, when I heard his voice, I felt something loosen in my chest that I had not realized was tight. I told him what I had found. I read him the petition number. I heard him go quiet in the particular way Felix goes quiet when he is processing something and does not want to speak before he has finished processing it. Then he said, "Sylvia, that petition was approved." I had not yet checked that part. It had been approved in August of 2022, for months before the gala, which meant that for 4 months on paper, Conrad Hawn was a co-inventor of a patent he had had no part in creating. For 4 months, Lorraine, who specialized in intellectual property law and who had almost certainly been the architect of the filing strategy, had been building the legal infrastructure for whatever came next. And what came next, Felix told me, was already in motion. He had received a letter 3 weeks earlier from a law firm he did not recognize, informing him that a dispute had been initiated regarding the revenue distribution terms of the licensing agreement. The letter cited the inventorship correction as the basis for a claim that the current split was inequitable. It requested that Felix voluntarily enter mediation within 60 days. Felix had assumed it was an administrative error. He had forwarded it to his own attorney and had not yet told me because he had not wanted to alarm me before the gala. We were both quiet for a moment after he said that. Then I said, "Felix, how long ago did you get that letter?" He said, 22 days ago. I said, "And the gala was 18 days ago." He said, yes. Conrad had given that speech knowing the legal process was already running. He had stood at a podium in front of 200 people and declared himself the origin of my work for days after the mediation request had been sent, which meant the speech was not arrogance. It was a calculated act of reputation management. He was establishing a public narrative before I had time to establish a counter-narrative. He was making witnesses out of my colleagues. I sat with that understanding for a long moment. Then I thought about Lorraine. Lorraine, who had spent 9 years watching me at family dinners. Lorraine, who asked questions with a lightness that made you answer before you realized what you had said. Lorraine, who specialized in finding structural weaknesses in patent agreements and who had access to one of the most accomplished intellectual property law firms in Boston. I thought about a dinner in 2020, 18 months before I stepped back from surgery, when Lorraine had asked me, very casually, over pasta with a glass of wine in her hand, whether Felix and I had ever formalized a succession plan for the patent in the event that one of us was no longer able to manage it. I had said we had attorneys for that. She had nodded and changed the subject. I now understood that she had been auditing me, testing what I knew, what I had documented, where the gaps were. And at some point she had found a gap, or manufactured one, or found someone inside the filing system who could manufacture one for her. The forged signature was the piece I kept returning to, because forging a signature on a USPTO petition is not something you do casually. It requires access to an original document bearing my signature, a skilled reproduction, and someone willing to submit it. The submission itself had been made by a law firm called Pellerin and Cross, which I had never heard of and which, when I searched for it, appeared to have been incorporated in Delaware 18 months before the filing and had no web presence, no listed attorneys, and no other recorded filings. A shell. Lorraine had built a shell firm to submit a forged petition using my signature to add her husband as co-inventor of a patent he did not create. And the USPTO had approved it. I want to be careful here about how I describe what I felt in the days that followed, because I do not want to perform emotion that I did not have. What I felt was not rage. It was something colder and more specific than rage. It was the recognition that I was dealing with people who had planned this carefully, who had resources and legal expertise, who had a 4-month head start, and who were counting on me to either not notice or not know what to do when I did. They had miscalculated on both counts. But I want to tell you about the part that hurt in a way that the legal dimensions did not, because I think it matters. 3 days after my call with Felix, Conrad called me. He called on a Thursday morning, which was unusual. We did not typically call each other on weekday mornings. I answered. He asked how I was feeling after the celebration. He said he had heard from several colleagues that my remarks at the end of the evening had been gracious. He said the foundation was already talking about naming a lecture series in my honor. He did not mention the patent. He did not mention the petition. He spoke to me for 11 minutes about nothing, in the warm and specific way he had spoken to the room at the gala, and I answered him in the same register he had used at the window by the harbor. Cordial. Even. Nothing on the surface. When he hung up, I sat for a long time thinking about the 12 years between us, about the way he had followed me into medicine, about the Christmas dinners and the birthday calls and the occasional conferences where we found each other across the room and nodded. I thought about our mother's word. Precise. I thought about how Conrad had always been precise about different things than I had. I was precise about what was true. Conrad, I now understood, had always been precise about what was useful. The night of the gala, he had been useful to himself in front of 200 people. What he did not know, what neither he nor Lorraine had accounted for, was that I had spent 40 years being precise about documentation. Every notebook, every draft, every date-stamped email, every version of every research file, going back to 2003, stored on a server that I maintained separately from the hospital system, that I had backed up quarterly, and that contained a chain of evidence so clear and so continuous that it did not require interpretation. It only required someone willing to use it. I was willing. The first thing I needed was a lawyer who had nothing to do with Boston. This was not paranoia. This was geometry. Conrad and Lorraine operated in Boston's legal and medical communities. Lorraine knew, by professional proximity, most of the senior IP attorneys in the city. If I walked into a firm she had any connection to, even a tenuous one, even a firm she had simply opposing counsel once, there was a risk of a conflict check triggering a conversation I did not want triggered. I needed someone outside her map entirely. I called a colleague in Philadelphia, a retired hospital administrator named Warren Chu, who had spent 30 years navigating medical institution politics and who knew every variety of professional betrayal that exists in this field. I did not tell him the specifics. I asked him for the name of an intellectual property litigator who was exceptionally good, worked outside Boston, and had experience with USPTO disputes specifically involving inventorship. He gave me 2 names. I researched both over a weekend. On Monday, I called the second one, a woman named Patricia Anand, who practiced out of Washington, D.C. and had spent 12 years at the USPTO before entering private practice. Her firm had handled 11 inventorship correction disputes in the past 8 years. She had won 9 of them. I told her everything on our first call. She listened without interrupting, which I respected. When I finished, she was quiet for a moment, and then she said, "Dr. Hawn, I need you to understand something before we go further. Reversing an approved USPTO inventorship correction is not impossible, but it requires demonstrating fraud on the agency, which is a high evidentiary standard. We will need documentation that is not just convincing. It needs to be airtight." I said, "I have 40 years of documentation. Tell me exactly what you need." She told me. Over the following 2 weeks, I began the process of pulling together everything I had kept since 2003. This is the part of the story where I want to be specific, because I think it matters to understand how the evidence actually worked, not as a dramatic reveal, but as the result of a discipline I had practiced so long it had become habit. When I started the research in 2003, I kept physical notebooks. I have 11 of them, each dated on the spine, each with entries written in my handwriting that include dates, observations, sketches of early instrument configurations, and notes from conversations with colleagues. The earliest entry referencing the core concept that would become the device is dated September 14th, 2003. I know this because I wrote the date at the top of every entry, every time, the way my mother had taught me to date every lab notebook in college. In 2007, when I began collaborating with Felix, we communicated almost entirely by email. Felix is also a careful person. He had archived every email we exchanged from 2007 onward. The chain documented the development of the device concept in real time. My initial proposal, his engineering responses, the back and forth over materials and tolerances, the point in 2009 when we agreed we had something worth patenting, the selection of the patent attorney, the drafts of the application. The provisional patent application, filed in November 2011, was timestamped by the USPTO's own electronic filing system. The full utility patent, granted in September 2013, carried the same timestamps. Both listed 2 inventors, Dr. Sylvia Hawn and Dr. Felix Okafor. Comrade Hawn appeared nowhere in any of these documents. But the most important piece of evidence was something I had not thought about in years until Patricia asked me a specific question during our second call. She said, "Dr. Hawn, is there any documentation from the period of Conrad's residency, roughly 2000 to 2004, that would show what research he was conducting and where?" I said I would look. Conrad had done his residency at a program in Cincinnati. He had published 2 papers during that period. I found them in about 20 minutes using a standard medical literature database. Both papers were on peripheral nerve repair. Neither had any connection to spinal cord instrumentation. Neither referenced any of the core observations that formed the basis of my device research. I sent the citations to Patricia. She called me back the same afternoon. She said, he claimed at the gala that the foundational research began with observations he made during his residency. His residency publications show 0 overlap with the device's technical domain. That is a documented contradiction between his public statement and the existing academic record. I said, yes. She said, that is very useful. The second track of work running parallel to the legal preparation was understanding exactly how the forged signature had been produced and submitted. Patricia engaged a forensic document examiner named Dr. Carol Whitfield, based in Maryland, who had testified in federal court on signature authentication more than 60 times. I provided Dr. Whitfield with 12 original documents bearing my authentic signature, sourced from different years and contexts, hospital correspondence, academic papers, legal filings from other matters. I also provided her with a certified copy of the inventorship correction petition bearing the signature Conrad and Lorraine had submitted as mine. Dr. Whitfield's analysis took 3 weeks. Her conclusion was unambiguous. The signature on the petition was not mine. She identified 7 specific characteristics that diverged from my authentic signature pattern, including pen pressure distribution, the specific arc of my capital S, and the way I terminate the descending stroke of the letter H. Her report was 41 pages and included side-by-side microscopic comparisons that were, she told me, among the clearest examples of skilled forgery she had examined in her career. Skilled, she emphasized, not amateur. Someone had studied my signature carefully before reproducing it. That pointed back to Lorraine. Patricia reached out through proper channels to request the original submission records from Pellerin and Cross, the Delaware firm that had filed the petition. The firm did not respond. Patricia then filed a records request directly with the USPTO for the submission metadata, the electronic filing data showing which IP address and registered account had submitted the petition. The submission had been made from a registered practitioner account. The account belonged to a paralegal whose name appeared nowhere else in the public record. No bar admission, no professional listings, no history of filings before or after this one. A ghost account created specifically for this submission and never used again. Patricia said, someone with detailed knowledge of USPTO filing procedures created a practitioner account using a false identity, submitted the forged petition, and then abandoned the account. This is not a mistake. This is a constructed system. I said, Lorraine spent 12 years doing IP law. She knows the filing procedures from the inside. Patricia said, I know. I am going to need you to be patient while we build this properly. If we move too fast, we hand them an opportunity to claim procedural error and delay everything by 18 months. I said, I have been patient for 40 years. A few more weeks will not be difficult. But there was one more piece I needed to find myself, and it was the piece that had been bothering me since the night I found the petition. If Conrad had filed an inventorship correction, adding himself as co-inventor, the natural next step, the step Lorraine would have planned for, was to use that correction as leverage to renegotiate the licensing revenue split, which was exactly what the letter to Felix had threatened. But there was a second possibility I had not yet confirmed, whether they had gone further. I pulled the full licensing agreement from my files. I read every amendment and addendum that had been filed since 2013. And on page 7 of an addendum filed in October of 2022, 2 months after the inventorship correction was approved, 2 months before the gala, I found a clause I had never seen before. It was a revenue assignment clause. It stated that Dr. Sylvia Hawn had agreed to assign 30% of her licensing revenue share to a corporate entity called Hawn Medical Innovations, LLC, effective immediately. I had never signed that clause. I had never heard of Hawn Medical Innovations, LLC. I searched the Delaware corporate registry. Hawn Medical Innovations, LLC had been incorporated in July of 2022. The registered agent was a service company. The managing member listed in the articles of organization was Conrad Hawn. He had not just added himself as co-inventor. He had created a company in my family name and used a second forged document to funnel 30% of my licensing revenue into it. By the time I found this, the clause had been active for 14 months. The licensing revenue during that period was approximately $3.2 million. 30% of that was $960,000. He had already taken nearly $1 million from me. I called Patricia that evening. I read her the clause. I gave her the LLC registration number. She was quiet for a moment that was slightly longer than her usual pauses. Then she said, Dr. Hawn, this changes the scope significantly. The forgery was the foundation, but this assignment clause, combined with the wire transfers that would have been made pursuant to it, gives us wire fraud. Federal jurisdiction. This is no longer just a USPTO dispute. I said, I know. She said, I need to ask you something directly. Are you prepared for what federal involvement means in terms of exposure for your brother and his wife? I thought about Conrad at the window by the harbor, the hand on my shoulder, the word origin. I said, Patricia, I spent 40 years repairing damage that other instruments were too imprecise to avoid. I am very comfortable with the idea of precision at this stage. She understood what I meant. We began coordinating with the FBI's Financial Crimes Unit the following week. The case agent assigned to the matter was a woman named Special Agent Dana Rice, who was methodical and unhurried in a way I immediately trusted. She reviewed Dr. Whitfield's forensic report, the USPTO submission metadata, the LLC registration, and the wire transfer records Patricia had subpoenaed from the licensing administrator. The wire transfers were the clearest part of the entire case. $963,000 had moved in 11 separate transactions over 14 months from the licensing administrator's account to Hawn Medical Innovations, LLC. Each transaction was documented. Each had a timestamp. Each had a corresponding record in the licensing administrator's system referencing the forged assignment clause as authorization. Wire fraud requires proof that a scheme to defraud used electronic communications across state lines. We had 11 transactions. We had forged authorization documents. We had a shell company registered in Delaware while the licensing administrator operated out of Illinois, and the transfers landed in a bank account in Massachusetts. 3 states. 11 wires. 1 scheme. Special Agent Rice said, "This is clean." Felix, when I told him the full picture, was quiet for a very long time. Then he said, "Sylvia, I want you to know something. The first time you showed me the notebook from 2003, the one with the September entry, I remember thinking that the idea was so clear and so complete in your handwriting that it looked like you had already built the device in your mind before you ever picked up an instrument." I said I had. He said, "I know. I just want to say it out loud, because I think it matters that someone who was there from the beginning says it clearly. This was yours." I did not have an answer for that. I thanked him, and I sat with it for a while after we hung up. There's a particular kind of loneliness that comes from having your own work taken from you by someone who knows you well enough to know exactly where to reach in and take it. It is not the loneliness of being unknown. It is the loneliness of being known and still considered expendable. I sat with that for exactly as long as I needed to. Then I went back to work. The execution was 4 weeks away, and I had one more thing to arrange that Patricia did not know about yet. Something that had nothing to do with the law and everything to do with the 200 witnesses Conrad had made at my gala. The annual Caldwell University Medical Center Research Symposium takes place every February in the same ballroom where my gala had been held. I had attended it for 22 consecutive years. I had presented at it 11 times. The guest list was largely identical to the gala. Department heads, senior surgeons, hospital administrators, research faculty, with the addition of pharmaceutical and medical device industry representatives who came specifically for the research presentations. It was, in other words, the same 200 people Conrad had made into witnesses 4 months earlier. I called the symposium chair, a colleague named Dr. Helen Marsh, whom I had known for 16 years, and I told her I would like to present this year. I told her I had something I wanted to share regarding the spinal instrumentation research that had been discussed at my celebration in October. I told her I thought it would be of significant interest to the attendees. Helen said she would be honored to have me on the program. I asked for the closing slot. She gave it to me without hesitation. I did not tell Helen what I was going to present. I told her it was a retrospective on the research timeline, which was accurate in the way that a seismograph reading is an accurate description of an earthquake. The symposium was on a Friday. On the Wednesday before it, Patricia filed the formal complaint with the USPTO's Office of Enrollment and Discipline, initiating the fraud proceeding against the Pellerin and Cross account and flagging the inventorship correction for emergency review. She simultaneously filed a civil complaint in federal district court in Massachusetts naming Conrad Hawn and Lorraine Hawn as defendants in a wire fraud and forgery action. The complaint was sealed pending service, which meant Conrad and Lorraine would not be notified until they were formally served. Special Agent Rice and her team executed a search warrant on the bank account associated with Hawn Medical Innovations, LLC on Thursday morning, freezing the remaining balance and seizing the transaction records. A second warrant was executed on the email accounts associated with the Pellerin and Cross practitioner filing, which yielded what Agent Rice later described to me as a substantial volume of relevant communications. Conrad and Lorraine did not yet know any of this had happened. They received service on Thursday evening at their home in Cambridge at 6:17 p.m. Patricia's process server documented the delivery. Conrad signed for it himself. Patricia called me immediately after confirmation. She said, "They have been served." I said, "Good. I will see them tomorrow," because Conrad and Lorraine were both registered for the symposium. Conrad was presenting a paper in the afternoon session on minimally invasive cervical procedures. Lorraine attended every year as his guest. I want to be honest about something. In the weeks of preparation, several people, Patricia, Felix, Warren Chu, who by then knew the full situation, had suggested that the symposium presentation was unnecessary, that the legal case was strong enough, that I did not need a public moment, that I could let the courts handle it quietly and with considerably less personal exposure. I listened to all of those arguments carefully, and I understood every one of them. And then I thought about 200 people rising to their feet in that ballroom while Conrad said the word origin. And I thought about the fact that public false testimony requires public correction. And I thought about the 400,000 patients whose restored mobility had been attributed in front of this community to a man who had never held my instruments or read my notebooks or spent a single hour in the work that produced them. I thought about precision. I went to the symposium. I arrived early, which I always do. I set up my presentation materials at the AV station while the room was still filling. The slides were simple, 11 of them. I had spent considerable time making them clear rather than dramatic because clarity was the point. I saw Conrad arrive at 9:43. He came in with Lorraine and 2 colleagues from his department. He was wearing the same confidence he had worn at the gala, which told me he had not yet decided how to respond to the service. Some people, when they receive legal papers, collapse immediately. Others go very still and continue functioning on the surface while processing beneath it. Conrad was the second kind. He saw me across the room and nodded. I nodded back. Lorraine did not look at me. That told me she understood the situation more clearly than Conrad did. I watched his afternoon presentation from a seat near the back. It was technically competent. He was a good surgeon and an adequate researcher, and his paper on cervical procedures was neither remarkable nor dishonest, which struck me as an interesting contrast to the rest of the situation. Conrad had not fabricated his entire career. He had simply decided at some point that his legitimate career was not enough and that mine was available. The closing session began at 4:15. Helen introduced me with warmth and with the particular kind of deference that 22 years of respected presence in a room earns. She mentioned the gala. She mentioned 50 years of practice. She said she was looking forward to what I would share. I walked to the podium. I looked at the room. I found Felix in the 3rd row. He had flown up from Atlanta the night before, which I had asked him to do, but had not explained why until he arrived, and I told him everything. He had sat with it for a long moment and then said, "I will be there." I found Conrad in the 7th row, center. Lorraine was beside him. His expression was composed. Hers was not quite. I said, "I want to thank Dr. Marsh for the opportunity to close this year's symposium. What I am going to share with you this afternoon is a documentation of the research timeline for the spinal instrumentation device that has been the subject of some discussion in this community recently. I am going to be precise. I am going to be brief. And I'm going to show you the actual record." I advanced to the first slide. It was a photograph of the cover of the first notebook. Black cover. Date written on the spine in my handwriting. September 2003. I said, "This is where the research began." In a notebook I purchased at a drugstore near the hospital in September of 2003. I am going to walk you through the documented timeline from that date to the patent filing in 2011. Because I believe this community deserves to see the actual record rather than a retrospective account offered without documentation. I advanced through the slides slowly and without drama. Each one showed a specific piece of documentation. The notebook entries with their dates. The earliest emails between Felix and me from 2007, with headers showing timestamps and our respective institutional addresses. The provisional patent application cover page from November 2011. the utility patent grant from September 2013, the licensing agreement from 2016. For each slide, I gave 1 or 2 sentences of context. Nothing more. The document spoke more clearly than I could. The room was very quiet. On the 8th slide, I showed Conrad's 2 residency publications from the Cincinnati program. I showed their publication dates, their subject matter, and their complete absence of any connection to spinal instrumentation or the technical domain of my device. I said, "These are the published research outputs from the period during which it has recently been claimed that the foundational observations for this device originated. I will allow the record to speak for itself." I heard a sound move through the room. Not quite a murmur. Something quieter than that. The sound of 200 people simultaneously recalibrating something they had believed. I looked at Conrad while I said it. He was looking at the slide. On the 9th slide, I showed Dr. Whitfield's forensic conclusion, 1 sentence, pulled from her 41-page report, stating that the signature on the USPTO inventorship correction petition did not match the authenticated signature of Dr. Sylvia Hawn across 7 identified characteristics. I did not explain the legal proceedings. I did not name the shell company. I did not mention the wire transfers or the FBI. I simply showed the forensic conclusion and let it sit there on the screen in a room full of people who understood what a forensic conclusion means. I said, "A formal complaint has been filed with the USPTO. Civil proceedings are underway in federal district court. I am not here to litigate those matters in this room. I am here because this community was present when a false account of this research was presented, and this community deserves to see the documented truth." On the 10th slide, I showed the original patent. Both names, Felix Okafor and Sylvia Hawn. The date, the patent number. Nothing else. On the 11th slide, I showed a single line of text. It said, "The research was always mine. The date stamps prove it." I said, "Thank you." I stepped back from the podium. The room did not applaud immediately. There was a pause of several seconds that felt longer than it was. The kind of pause that happens when a room full of intelligent people is deciding how to respond to something that has rearranged their understanding of a situation they thought they already understood. Then Helen Marsh stood up and began to clap. Not the performative clapping of a social obligation. The deliberate, considered clapping of someone who has just witnessed something they believe should be witnessed. Felix stood up. His face was composed, but his eyes were not. And I will not say more about that because it belongs to him. Others followed. Not everyone. About half the room. The other half sat in a stillness that was not disapproval, but processing. Conrad did not applaud. He sat with his hands in his lap and looked at the floor in front of him. The confidence he had worn when he arrived had not collapsed dramatically. It had simply gone somewhere I could not see, like a tide pulling back from a shore very quickly. Lorraine had turned slightly sideways in her seat and was looking at the wall to her left. She did not look at me once during the presentation. She did not look at Conrad. She was, I recognized, already in attorney mode, calculating, containing, determining what came next from a legal standpoint. What came next, she already knew, because she had been served the night before. What she did not know was that Special Agent Rice was in the building. Agent Rice had attended as an observer. She had no role in the presentation and had not coordinated it with me. Patricia had informed her as a courtesy, and she had decided on her own to be present. She told me afterward that in financial crimes cases, she liked to observe how subjects behaved in public settings when they believed themselves to be in control. She said Conrad's composure was consistent with someone who had decided on a strategy of denial. She said Lorraine's lateral gaze was consistent with someone calculating exposure. She said both of those behavioral patterns were useful to have documented. I did not ask how. After the formal session ended, several colleagues approached me. Dr. Raymond Alcott, who had been chief of neurosurgery at a hospital in New York for 14 years and who had been at the gala, shook my hand and said, "Sylvia, I owe you an apology." I did not question what I heard in October, and I should have. I said, "You heard what you were meant to hear. That is not your failure." He nodded and stepped aside. A younger surgeon whose name I did not know, she could not have been more than 35, stopped me near the door and said she had done her fellowship in spinal surgery and that the device had been in use throughout her training and that she had written a paper on its outcomes and that she wanted me to know she knew whose work it was. I thanked her. I meant it completely. Conrad left the room before the session formally closed. I did not see him go. Someone told me later that he and Lorraine left through the side exit near the AV station and did not speak to anyone on the way out. Felix and I had dinner that evening at a restaurant near the harbor, the same harbor I had looked out over on the night of the gala. We did not talk about Conrad or Lorraine or the legal proceedings for most of the meal. We talked about the research, about the notebook, about the specific problem we had been trying to solve in 2003 and the moment in 2009 when Felix had sent me an email at 2 a.m. saying, "I think I have the mechanism." I still have that email. It is in the archive. We talked about the 400,000 patients, about what it means to build something that enters the world and does its work quietly in operating rooms, in the hands of surgeons you will never meet, in bodies you will never see. About how that kind of work does not require credit to be real. It is real because it functions. It is real because the outcomes are documented. It is real because the date stamps exist, and date stamps, unlike memory and unlike ambition, do not revise themselves. Felix said, "You know, the thing about Conrad's mistake, the fundamental mistake, not the legal one, is that he chose a target whose entire career was built on not letting imprecision stand." I said, "That is exactly right." He said he should have known better. He watched you for 30 years. I said he saw what he wanted to see, which is its own kind of imprecision. Felix raised his glass. I raised mine. We did not make a toast. We did not need to. The federal case moved at the pace federal cases move, which is to say deliberately and without regard for anyone's impatience. I want to walk you through what happened in the order it happened, because the sequence matters and because I have seen versions of stories like this compressed into a single paragraph of consequences that makes justice look easy. It is not easy. It is procedural and exhausting, and it requires sustained attention over a long period of time. That is the truth of it, and I think you deserve the truth. In the week following the symposium, Patricia filed a motion for emergency injunctive relief in federal district court, requesting that the court freeze all assets associated with Hawn Medical Innovations, LLC, pending resolution of the civil complaint. The motion was granted within 72 hours. The LLC account, which had already been frozen by the FBI's search warrant action, was formally placed under court supervision. Conrad could not move, transfer, or access any of those funds. The USPTO's Office of Enrollment and Discipline opened its formal investigation into the Pellerin and Cross practitioner account in the same week. Because the account had been used to submit a document containing a forged signature of a named inventor, the matter was flagged for coordination with the FBI. Special Agent Rice's team and the USPTO investigators began working in parallel rather than separately, which Patricia said was unusual and reflected how cleanly the evidence had been assembled. Conrad and Lorraine retained separate attorneys, which Patricia told me was the first indicator that their legal strategy was already fracturing. When parties who acted together in a scheme retain separate counsel, it typically means each is considering the possibility of cooperation, of providing information about the other in exchange for reduced exposure. Separate attorneys means the alliance is already in question. Conrad's attorney filed a motion to dismiss the civil complaint on the grounds that the inventorship correction had been approved through proper USPTO channels and that any dispute should be resolved through administrative rather than judicial proceedings. The motion was denied in 6 weeks. The judge's written denial cited Dr. Whitfield's forensic report and the shell company registration as sufficient basis for fraud claims that exceeded administrative jurisdiction. Lorraine's attorney made no motions in the first 60 days. Patricia said that silence from Lorraine's side was more informative than Conrad's motion had been. She was right. In April, 14 weeks after the symposium, Lorraine Hawn entered into a cooperation agreement with federal prosecutors. I want to be precise about what that means because I think it is important to understand rather than simply absorb. Lorraine did not confess to everything voluntarily out of remorse. She made a calculation. She had the most detailed knowledge of how the scheme had been constructed, the shell firm, the practitioner account, the forged documents, the revenue assignment clause, and prosecutors wanted that knowledge. In exchange for her cooperation and her testimony, she received a negotiated charge of 1 count of wire fraud with a sentencing recommendation of 18 months, reduced from a potential exposure that Patricia estimated at 8 to 12 years if both counts had gone to trial. Lorraine's cooperation produced something that had been the one remaining gap in the evidence: direct documentation of how my signature had been obtained for forgery. In 2019, Lorraine had requested a copy of a real estate document I had signed in connection with a property matter that briefly involved Conrad. It was a routine document, a letter of acknowledgement, and I had signed it and thought nothing of it. Lorraine had retained a high-resolution scan of that signature. She had contracted the forgery work to an individual in Providence, whose name I will not include here, because that matter is subject to its own separate proceeding. She had then used the forged signature on both the U.S. Betrayal petition and the revenue assignment clause. The real estate letter, a document I had signed without a second thought because it appeared to be administrative, because I had no reason at that moment to be suspicious of my brother's wife requesting a routine signature. This is the part of the story I find most instructive, and I will return to it. Conrad, once Lorraine's cooperation became known to his legal team, changed his strategy. His attorney approached prosecutors in May with a proffer and offered to provide information in exchange for consideration. The proffer was accepted for review, but ultimately produced limited new information because Lorraine had already provided the substantive account and because Conrad's role, while central, had been primarily that of the beneficiary and the public face rather than the architect. The distinction mattered at sentencing. Lorraine had built it. Conrad had performed it and collected from it. The criminal case concluded in September, 11 months after the symposium. Conrad pleaded guilty to 1 count of wire fraud and 1 count of filing a fraudulent document with a federal agency. His sentencing guidelines, adjusted for his late cooperation and the absence of prior criminal history, produced a sentence of 38 months in federal prison, 3 years of supervised release, and full restitution of all funds transferred through Hawn Medical Innovations, LLC. The restitution figure, finalized by the court, was $963,417. Every cent. Lorraine received 18 months, as negotiated, with eligibility for release after serving 15. She was also permanently disbarred by the Massachusetts Board of Bar Overseers, which conducted its own proceeding concurrent with the criminal case. The disbarment was not a surprise. Using legal expertise to construct a fraud scheme tends to produce that outcome. The USPTO formally vacated the inventorship correction in October, restoring the patent to its original 2 inventor status, Felix Okafor and Sylvia Hawn. The agency also issued an internal review recommendation regarding the verification procedures for inventorship correction petitions, citing the case as an example of gaps in signature authentication protocols. Patricia told me that recommendation would likely result in procedural changes across the office. Something good, coming from something that had been done badly. That happens sometimes if you push far enough. The civil case settled in November. Conrad, through his attorney, agreed to a judgment of $1.4 million covering the licensing revenue diverted, the legal costs I had incurred, and damages for the reputational harm caused by the false public statements at the gala. His personal assets, which were considerable given 20 years of surgical income, were sufficient to satisfy the judgment after the criminal restitution was applied. Felix and I had a long call the evening after the civil settlement was confirmed. He asked me how I felt. I thought about it for a moment before I answered, because I wanted to answer accurately. I said, I feel like the record is correct again, which is what I was trying to achieve. He said, is that enough? I said, it has to be. The rest of it, the why, the how someone decides to do this to a person they have known their entire life, I do not think I am going to find a satisfying answer to that. So I am choosing not to look for one. He said, that seems right. I said, Felix, can I ask you something? He said, of course. I said, that email you sent me in 2009, at 2 a.m, I think I have the mechanism. He laughed. He said, I remember it. I said, what made you send it at 2 a.m? He said, because I had been awake since 11 trying to talk myself out of it, and I finally decided the idea was better than my doubts about it. I said, That is the best description of research I have ever heard. He laughed again. I laughed too, which surprised me slightly, and then did not surprise me at all. Conrad is currently serving his sentence at a federal correctional institution in New England. I did not know the details of his daily life there, and I have not sought them. His surgical license was suspended by the Massachusetts Board of Registration in Medicine, pending the outcome of the criminal proceedings, and was formally revoked in December. 30 years of surgical practice ended. I think about that sometimes. Not with satisfaction, exactly. With something more complicated than satisfaction. Conrad was a real surgeon. He saved real patients. The work he did legitimately was not nothing, and I am precise enough to acknowledge that even now. What he could not tolerate was that my legitimate work was larger than his, and that intolerance grew into something that destroyed everything he had actually built. That is the part worth sitting with. Lorraine was released after 15 months. I do not know where she is. I do not need to know. Dr. Felix Okafor and I are currently co-authoring a paper on the long-term outcomes of the device across its first decade of clinical use. It is the most straightforward thing we have done together since the original research, and I find that I enjoy it in a way that is almost uncomplicated. Almost. I returned to consulting work with the global medical nonprofit in January. I traveled to 3 countries in the first quarter. I was in an operating room in Nairobi in February. Not operating, observing, advising, and I watched a surgeon use an instrument based on my device to complete a spinal decompression procedure on a 14-year-old boy. The surgeon was young and careful and precise. I did not introduce myself afterward. I was not there for that. I stood in the corridor outside the theater, and I thought about September 2003. A notebook, a drugstore, an observation that would not leave me alone until I wrote it down. That is where it began. That is where it will always have begun, regardless of what anyone says at a podium, regardless of what documents anyone files or forges or constructs in a ballroom in Boston. The date stamps do not revise themselves. I want to leave you with something that is not a lesson. Exactly. I am not interested in lessons. I am interested in what is actually true. Here is what is actually true. The real estate letter I signed without a second thought, the ordinary document I handed over because I had no reason to be suspicious. That is the thing that made the fraud possible. Not my inattention. I was not inattentive. The document was legitimate in its appearance and its request. What made it useful to Lorraine was that I trusted the context I was operating in. I trusted Conrad because he was my brother. I trusted Lorraine because she was his wife. I trusted the ordinary flow of family paperwork because families have ordinary paperwork, and I was busy and I had no reason at that moment to treat a routine signature as a security risk. That is not a failure of intelligence or expertise. That is what it looks like when people who know you well enough decide to use that knowledge against you. I cannot tell you to stop trusting people. I am not going to offer that as wisdom because it is not wisdom. It is just fear in a good coat. What I can tell you is this. The documentation I had kept since 2003, the notebooks, the emails, the archives, the habit of precision my mother had given me before I knew I would ever need it, that documentation was not kept because I was suspicious. It was kept because I believed the work was worth recording accurately. Keep the record, not because you expect betrayal. Keep it because the work is worth it. Keep it because precision is its own form of protection, even when you do not know you need protecting. Keep it because date stamps do not lie, and someday not necessarily in the way you expect, not necessarily on a timeline you would choose. That will matter. It mattered for me. It will matter for someone watching this right now. That is the only thing I am certain of.